across criminal defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So we received an interesting inquiry here on our YouTube channel. This has to do with a premeditated killing. Let's see here. For years, I've had problems with my neighbor, and one afternoon, arriving home, his 5-year-old son crossed the street. I hit him and he died. Due to the above problems, he accused me of intentionally killing his son. Well, first of all, yeah, well, he's not even the victim. He's the father of the victim. You know, he could say whatever he says, and obviously, you know, any prior problems that you might have had definitely will be evidence that could theoretically be used against you. But, you know, at the end of the day, you know, there may be witnesses, there may be cameras, and not only that, but, you know, there might be evidence suggesting otherwise. For instance, you know, if you have a 5-year-old darting across the street and you hit him, if there are tire marks indicating that you clearly tried to stop and you didn't just run off, ha 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 ha, well then you stopped and, you know, you flipped out, called the ambulance, you know, they could see that you clearly did everything to stop, you didn't, you know, search for him, you didn't go looking for him to hit him, well then that's going to be classified as an accident and that's it. However, if there are witnesses to say, oh yeah, the 5-year-old was just walking slowly across the street and that he came with his car and he purposefully aimed it and he actually turned it against the kid, well then yeah, then at that point we'd be talking about potentially a murder. You know, it could theoretically even be first-degree murder. Which would be obviously felony under Penal Code Section 187 that carries first degree. It's actually life or death. But, you know, the other thing that needs to be factored in is your own history as well. And also, I mean, these things do happen. I mean, this definitely needs to be considered. Like I said, witnesses are going to help tremendously. The tire marks are going to help tremendously. And also just the way you behaved on the phone, if you're the one who flipped out and called 911 regarding what happened. Now, if you hit the child and just took off, you kept going, well, that's not going to be so good. I mean, you could be charged with murder. At the very least, you'll get charged with a felony hit and run under Penal Code, under Vehicle Code Section 20001, which carries up to 3 years state prison. But like I said, if you stayed at the scene, they could see tire marks showing that you didn't run into the child. Matter of fact, if you try to swerve away from the child, they could see that, you know, that you try to brake. They're going to have difficulty showing beyond a reasonable doubt. And remember, it's the DA that has to prove this beyond a reasonable doubt that you purposefully killed this child. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of arson, criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.